I think it's probably similar to what other folks who are litigators do. So not really specific to the practice area, but the way in which I practice law, which is mostly litigation. So that means on a day-to-day basis, I might be meeting a new client and forging a relationship with that client, developing rapport with that client. I might be counseling another client about milestones in the litigation, or it may be an initial counseling where we're just talking about where do we go from here? How do we address your problem? I might be negotiating in a conflict between two parties and trying to secure a favorable outcome for my client. And I might be involved in a mediation with a neutral third party who's trying to help the parties to work out their differences. Or in some of the more boring stuff, I might be pouring through discovery documents and trying to discern patterns or culpability. My role used to involve a lot more time in the courtroom, but post-pandemic, a lot of the federal courts realized that you don't need to actually drag people all the way into court, which was honestly was very exciting and thrilling to go into court in your full, attorney garb and be able to argue before a judge and see them face to face. A lot of the court time that I have now, is on a conference call or, rarely even on a Teams call where you have a remote platform. So you really don't get to see people's faces. You don't get those opportunities for schmoozing in between, waiting for the judge and discussing the case, considering the possibility of settling. Those organic opportunities that you used to get with going into court in person, those I don't get as much. But when I still do get to go in, whether it's for oral argument on a contested issue or otherwise, it's still really, really exciting and always fun to be there thinking on your feet, being in those impressive, inspiring spaces and getting to synthesize all the skills that we're trained to. So I practice in the field of employment discrimination, in particular within employment law, and I think there are kind of two main components of the law that I'm practicing in this area that I find really satisfying. One is the therapeutic value and benefits that I bring to my clients. So them being able to talk about how they felt discriminated against, being validated by me in their story, in their impressions, and their intuitions, having a sympathetic listener, and then secondly, the procedural justice that I can offer them by making sure that the litigation process allows them to be heard with respect and tell their story in a way that helps them hopefully get some closure on whatever they've come to me about and move to the next chapter in their lives. As an employment lawyer representing employees, I think there are two fundamental challenges that we face as plaintiffs' counsel. One is the information asymmetry. Obviously, employers have all the documents, employers have all the witnesses, and so that disparity between what we know and what evidence we're able to cull versus what an employer can produce creates an intrinsic challenge within this area of the law. I also find very challenging that it's sort of a David and Goliath scenario in many of these cases where employees have limited resources, they don't have a revenue stream necessarily, they haven't found a new job yet, and so they're under a lot of pressure to quickly litigate and quickly resolve their cases. Whereas For some employers, they're sophisticated legal consumers and this is business as usual for them. And so they can continue to litigate the case without any impact on the day-to-day for them. And so I think those are two challenges in working in this particular area of the law. Yeah, so what I think about my career path what I think would be helpful to know is that my first job out of law school was at a legal services office in Brooklyn. And my second job was at a nonprofit housing advocacy organization where we prosecuted fair housing cases. And I think when you learn to practice, not from the vantage point of a private practitioner where there are all kinds of issues with how much money and time you're going to spend on prosecuting a case, but where it's sort of, you may have a very large docket, but the time you spend can be infinite, can be unlimited, really taught me in working in those environments, really taught me about best practices for client-centered lawyering. So two answers to that. One, I went to Northeastern University School of Law, and so they have an internship program where you end up getting 4 internships over the course of your 3 years of law school. And that was phenomenal because you got to actually get out there and practice and see what lawyering really looks like, as opposed to, thinking that whatever was happening in the black letter law classes was what law is really practiced like. So I think getting out there and getting experiences obviously was an internship. So it's almost like what happened in between law school that was most helpful. But to the extent that law school itself was helpful to me in preparing me for this particular career path, I would say would be the experiential and clinical classes, because those are opportunities to really delve into what lawyering is like on a day-to-day basis, because the substantive law is always going to change. That's why continuing legal education is so important, because you know that your practice area is going to be changing, that there are going to be cases that are coming out every year that are going to fundamentally alter the way you practice law. So learning how to lawyer, as opposed to focusing all your time learning about some discrete area of the law that you may end up having to change for, one reason or the other, or may shift, careers for one reason or the other, I think is a more beneficial way to prepare for the real task and challenge of lawyering. So I would say to anyone that is interested in practicing in the employment law sphere on either side of the V, that you need 2 basic skills in order to navigate the parties, the issues, the conflicts that come before you. One is that you need to learn how to and develop an ability to handle people's emotions, because this area of law is incredibly emotionally charged. Both sides are feeling very, very strong emotion when they come to the table on these cases. And the second thing that I think you would want to take your own personal temperature on before entering into this area of the law is your appetite for conflict. But because of how emotionally charged these cases are, the conflict is also very intense and can escalate before and if you ever see a resolution come out of the case. So being able to kind of marinate in the conflict and sustain the challenges, the difficulties, the fatigue, the surprises that come along with these kinds of conflicts, I think is really important to determining whether this is right for you.